So we all understand that free speech is pretty fundamental to democracy, right?
Absolutely, foundational.
But that point where expressing yourself might, tip over into causing trouble, maybe even breaking the law, that's such a tricky balance.
It really is, and it's fascinating when the courts have to step in and draw those lines.
Exactly. So today we're doing a deep dive into a specific, very recent Supreme Court decision. It's Imran Pratapgarhi versus the state of Gujarat.
That's the one from 2025. You might see it cited as 2025 INSC 410.
And it involves a member of parliament, a member of the Rajya Sabha, facing legal action over sharing a poem.
That's right. And our goal, really, for you listening, is to unpack what the Supreme Court judgment actually means.
How do the courts in India figure out this free speech stuff, especially when maybe the words are a bit controversial?
Yeah, and how critical context is in all this. We want you to get those aha moments, without drowning in legalese.
And we're focusing just on what the Supreme Court itself said.
Right.
Using their judgment.
Exactly. Straight from the source.
Okay, let's set the scene then. What actually happened? What's the story behind this poem getting shared?
Right. So the background, it's fairly straightforward. You have this person, a member of the Rajya Sabha.
Okay.
And he posted a video on what used to be Twitter.
Right.
It was a video of a poem being recited, happened at a mass wedding event. And the poem itself was originally in Urdu.
Okay, Urdu. And what was the poem about? Like, what was the gist of it?
Well, according to the Supreme Court, they looked closely at the Urdu and an English translation they had. It seems the poem used, let's say, metaphorical language. It talked about facing injustice, but with love, and about sacrificing personal interests for truth.
Okay. On the face of it, that sounds, well, not like something that immediately screams legal trouble. So what went wrong? Why the complaint?
Well, someone filed a complaint. The claim was that the poem stirred up bad feelings, animosity between different groups, that it promoted hatred, and even threatened, national unity.
Wow, serious allegations.
Very. And based on that complaint, the authorities went ahead and registered an FIR, a first information report, against the MP.
Got it. An FIR. And what specific laws did they say were broken?
They listed quite a few sections from the new penal code, the Bharatiya Nyaya Sanhita, the BNSS 2023.
Like which ones?
Okay, so there was Section 196 that's about promoting enmity between groups. Section 197, which is about statements causing public mischief or disorder.
Okay.
Then Sections 299 and 302, those deal with hurting religious feelings, deliberately trying to wound them. And Section 57 about abetting illegal acts.
A whole list.
Yeah, and they also mentioned Section 35 of the BNS, although the court didn't really get into the weeds on that one in its reasoning.
And initially, did the MP try to get this stopped earlier?
He did. He went to the High Court, asked them to quash the FIR, but the High Court initially said no, they dismissed his petition.
Okay, so that's how it ended up as the Supreme Court. Pretty big deal. What did the top court finally decide?
The Supreme Court saw it very differently. They sided completely with the member of parliament.
So they allowed his appeal?
Yes, allowed the appeal, and crucially, they quashed the FIR entirely. Wiped it out.
And did they say why it was wrong?
Oh, yeah. They were quite blunt. They called the registration of the FIR a mechanical exercise without application of mind. Strong words.
That is strong.
And they didn't stop there. They said it was a clear abuse of the legal process and, importantly, a violation of his fundamental right to freedom of speech and expression under Article 19(1) of the Constitution.
Okay, wait, that's a major ruling. How did they justify that? What was the core of their thinking?
Well, a big part of it was them really digging into the poem itself. The court, carefully went through the original Urdu and the English translation.
And what did they find when they did that?
This is key. They found quite clearly that the poem had nothing to do with any religion, community, region, or race.
So it wasn't targeting anyone specific.
Exactly that. The court stressed it didn't harm national integration, didn't threaten India's sovereignty, unity, integrity, none of that.
And what about the content itself, the message?
Right. They pointed out the poem actually preaches nonviolence, that encourages responding to injustice with love and sacrifice, not violence.
That's almost the opposite of the accusation then.
Pretty much. And you mentioned symbols earlier. There was talk about a throne in the poem.
Ah, yes, the throne. How did the court read that?
He saw it symbolically as representing opposition to injustice generally, not, trying to incite people against a specific community or the government or anything like that, just injustice in the abstract.
Okay, that makes sense. So the court's view was poems not offensive, not targeting anyone, But how did they link that back to those specific BNS sections in the FIR? Did they go through them one by one?
They did, yeah, methodically. For Section 196, the promoting enmity one, they were very clear. The poem did not promote disharmony, hatred, ill will between any groups, religious, racial, whatever.
No hatred promoted.
And it didn't disturb public peace or even try to.
Okay. What about Section 197, the public mischief charge?
Dismiss that too. Their reasoning was simple. The poem didn't make any assertion or imputation against any particular group, religious, racial, language, caste, community, none of that.
Right. No specific target. And the religious feelings sections, 299 and 302.
Here the court was particularly direct. They called using Section 299 for outraging religious feelings ridiculous.
Ridiculous. Wow.
Yes, because, they said, the poem just didn't insult any religious beliefs at all. And similarly, for Section 302, which needs deliberate intent to wound religious feelings, they found that completely, wholly baseless.
Just no grounds for it.
None whatsoever. And the last one, Section 57, about abetting illegal acts.
What about that?
Same story. No basis for it. No illegal act was proven or even really alleged in connection with the poem.
Okay, so the poem itself didn't meet the criteria for any of those offenses. But the court also talked about procedure, didn't they? Something about what should have happened before the FIR.
Yes. This is super important. The Supreme Court really focused on Section 173 of the BNSS, the procedural code. Subsection 1 says an FIR should only be registered if it actually discloses a cognizable offense.
Meaning an offense the police can investigate directly.
Right. But then they pointed to subsection 3 of 173. This says that for offenses where the punishment is potentially between 3 and 7 years.
Which covers most of the sections used here, right? Except maybe Section 57.
Exactly. For those sections, the police are actually supposed to conduct a preliminary inquiry first, before registering the FIR.
A preliminary inquiry. Why is that step so critical, especially with speech?
The court explained that when you're dealing with allegations based on words spoken or written, that might touch on the exceptions to free speech in Article 19(2).
Like incitement, defamation, public order.
Precisely those. The police need to be extra careful. They should use this preliminary check to properly assess the situation, see if there's really something there, before jumping to an FIR. They even mentioned the police duty under Article 51AA to uphold constitutional ideals.
That makes a lot of sense. Don't rush to file charges based on words without checking if they actually cross a legal line. Did the court mention a standard for how to judge speech? Something about strong-minded men.
Yes, they did. This is a really interesting legal principle they quoted from an older case, Bhagwati Charan Shukla. The idea is that the effect of words shouldn't be judged by how, say, the most easily offended or hypersensitive person might react.
Okay, so how should it be judged?
It should be judged by the standards of reasonable, strong-minded, firm, and courageous men, and not those of weak and vacillating minds.
Huh. So the bar for speech being considered truly harmful or inciting is actually pretty high. It assumes a certain level of resilience in the audience.
Exactly. It implies society needs a certain robustness, a tolerance for different, maybe even challenging views. It pushes back against censoring things just because someone might be offended.
And applying that standard to this poem.
The court found the poem clearly didn't cross that line. It didn't incite hatred or animosity when viewed through that lens. They repeated, again, it actually promoted peaceful resilience.
Okay. Another legal term that often comes up is mens rea, intention. Did that play a role?
A huge role, especially for offenses like Section 196, promoting enmity. The court stressed that mens rea, guilty mind, a deliberate intention to cause the harm, is essential.
You need to mean to cause trouble.
Basically, yes. It can't just be accidental or misinterpreted. They pointed to other cases they decided, like Manzar Saeed Khan and Patricia Mukim, to back this up.
And in this specific case, did they find intent?
No. The Supreme Court explicitly found there was no deliberate intention on the MP's part to promote enmity or ill will. So a fundamental ingredient of the alleged crime was just missing.
Right. It sounds like the Supreme Court wasn't too pleased with the High Court's earlier decision either.
No, they weren't. They quite clearly criticized the High Court for not stepping in earlier.
Why? What was the High Court's reasoning?
The High Court had relied on the idea that the investigation was still at an early stage. But the Supreme Court said, look, even at an early stage, if there's clearly no prima facie case...
Meaning not even the basic suggestion of a crime.
Exactly. If there's no basic evidence, the courts must intervene and quash the proceedings. They can't just let it drag on. It's about preventing the legal system from being misused.
Preventing abuse of process.
Precisely. And throughout all this, the Supreme Court kept coming back to the bigger picture, right? The value of free expression.
It seems like it.
Absolutely. They used some powerful language, called free expression an integral part of a healthy, civilized society, and said it's essential for a dignified life, which is guaranteed by Article 21.
So it's not just a right, it's fundamental to dignity.
That's the idea. And they emphasized that courts have to protect this right, even when the speech is unpopular or makes people uncomfortable. They brought up other key free speech cases like Anand Chintamani Dihe and Shreya Singhal.
To make what point?
To stress that tolerance for different views, for dissent, even for stuff that's not mainstream, is a core constitutional value in India.
Okay, so if we had to boil down the Supreme Court's main conclusions here, what are the key takeaways they highlighted?
They summed it up pretty well at the end. First, that rule about preliminary inquiry is under Section 173(3) of the BNSS. It's mandatory for those specific offenses, punishment between 3 and 7 years.
Got it. Police have to check first sometimes.
Second, police need to be sensitive, especially when free speech under Article 19(1) is involved. Handle with care.
Makes sense.
And finally, you can't just use FIRs based on speech to shut people down or stifle fundamental freedoms unless the speech genuinely falls under those specific limited exceptions allowed in Article 19(2) of the Constitution.
Okay, so this whole deep dive into the Imran Pratapgarhi case, it really hammers home how vital it is to look at context, right, and intent when you're assessing speech that someone finds problematic.
That really is the core insight, isn't it? Seeing the legal system at its highest level step in like this to guard those fundamental rights, to stop the law being used to silence expression, even if, the expression itself is debatable or controversial for some. It's quite significant.
It really gives you something to think about. How does a ruling like this affect how we think about expressing different views, maybe even dissent in public spaces? And what's our role, as people who hear or read things? How do we interpret and react?
Yeah.
It's definitely worth mulling over that balanced free speech on one hand, keeping society harmonious on the other, especially after looking at this Supreme Court decision.